We are live, Senator Sears.
And good morning. This is Joint Justice Oversight Committee meeting. It's our first of this new biennium, or new year. I guess it's new biennium too. And I'm Senator Dick Sears from Bennington County. Unfortunately, we are meeting remotely because the State House is closed due to flooding. And please bear with us. I know there will be technical difficulties, and those who are watching on YouTube, we thank you. And those that are trying to log in through the legislative website, it may not be working. You may have to go directly through Zoom using the passcode that we sent earlier today. So with that, I think it'd be a good idea to introduce the whole committee, starting with Representative Emmons, and who is the vice chair.
Thank you, Senator. Representative Alice Emmons from Springfield, and vice chair of this committee and chair of the House Corrections and Institutions Committee.
Hopper.
Representative Topper McFawn, member of this committee. I'm also the vice chair of the Healthcare Committee.
Senator Norris. I'm going by what I have on my screen. I don't know if other people have the same. We can't hear you, Bob. You're
muted.
Can you hear me now?
Yeah.
Good morning, Senator Bob Norris. I represent Franklin County, to include the town of Elberg in Grand Isle County, and I sit on Senate Judiciary and Senate GovOps.
Senator Warner. Irene.
Hi, thank you. Irene Renner, solo senator for Chittenden North, which is a new district including Milton, Westford, Fairfax, and Essex. I'm the clerk of Agriculture and the clerk of the Institution Committee, and I'm a member of this committee. Thanks.
Representative Malone. You're muted as well.
Yeah, Representative Trevor Squirrel, representing Underhill and Jericho on this committee. I'm on a House Appropriations. I also chair LCAR committee.
Representative Lalonde is muted.
Yeah, Representative Martin Lalonde, representative from South Burlington, also the chair of House Judiciary Committee. Good morning.
And finally, Senator Rom Hinsdale.
Good morning, Senator Keisha Rom Hinsdale, Chittenden Southeast, chair of Senate Economic Development, Housing, and General Affairs. Also sit on Senate Finance. Here is Mira sleeping, and probably will only join me when we're remote. I do have help for when we're in the State House, but I will be on and off camera, just taking care of her.
That's fine. I'm going to turn it over to our legislative council. Before I do, I just want to express our thoughts for all of Vermonters who've been affected by the flooding. And I know we're all here at this meeting, but we also have our minds on our fellow Vermonters who have been affected by this event. And so we are all prepared to help as much as we can as representatives and senators. But we hope everybody is staying safe, and so our thoughts are with you. And I saw a lot of things on Facebook about Vermont Strong, and I think we have to bring that back. With that, I'll turn it over to Ben Novogowski, our legislative counsel.
Thank you, Senator Sears. As you said, my name is Ben Novogowski. I'm an attorney for legislative counsel who also staffs justice oversight over the summer. During the session, for those of you, I know most of you, there are a couple, Senator Renner and Representative McFawn. I don't think I've had the pleasure of meeting yet, but I staff House Corrections, House Judiciary, Senate Judiciary, and sometimes make some cameo appearances in GovOps in both chambers as well. Nice to meet you, Representative McFawn and Senator Renner. And actually, Representative McFawn, I think I grew up playing hockey, so I think I played you many times. And I played for Stowe growing up. So so not our first time, I guess, meeting, at least on the ice. So but I figured in an effort to just a full disclosure, I figured I should disclose any potential conflicts. I joke.
Did you win or lose?
I think we were pretty evenly split at that time. So, you know, it was always a good match.
Yeah. Well, that was in the good years of Stowe.
Yeah. But anyway, on a more serious note, I prepared a PowerPoint for the committee just to give an overview of the committee's charge and the summer work before the committee and some reports that are due to try to help sort of set up the tone for the summer, I suppose. So if there are any questions, feel free to jump in. Otherwise, I'll go ahead and share my screen and get started.
Recognize that Representative Wood has just joined us from Waterbury, and we really appreciate her being here. And we know there are serious problems in Waterbury, and we did introduce the entire committee, but who is here?
I think I know everyone. Thank you.
I think you do too. So
all righty. And just to let you know, we built the state office complex back the way we should. And I talked to the plant manager 5 minutes ago, and there's not a drop of water inside.
that's good news.
Yes, I can see Alice. I was going to text you.
Yes. Oh, that's such good news. That's
Yeah.
great.
Yes.
Thanks for joining us, Representative.
Okay.
Wood. We know you've got 1,000 things going on right now. Ben, if you would present the PowerPoint, be great.
Okay, so if everybody can see my screen. Today is July 11th, and welcome to the Joint Legislative Justice Oversight Committee. As a brief overview, the committee was first established in 2015, Act number 58 in the budget, well, at least in its current iteration. And that's codified in Chapter 3 of Title 2. Basically, the committee oversees the Department of Corrections, its strategic operating policy development, encouraging communication between DOC and sort of the other branches that it interacts with, and also to assist with Vermont's juvenile and criminal justice systems. So evaluating the statewide system of pretrial services, restorative programs, and other relevant things under that purview. Also assessing consistency, cost efficiency of the systems, and that restorative justice principles are reflected in our statutes and the policies that the DOC and other agencies implement. And also the timeliness of judicial proceedings, which, as many of you know, the court backlog has been quite the bear over the last couple of years. So if there are no questions about the charge of the committee, I'll move into sort of an overview of the summer work. Right now, there's some work for the committee to do over the summer. Through Act 22 will be a review of the continuity of treatment upon reentry of incarcerated individuals, recommendations that the committee is supposed to make. Under Act 28, there are some companies examination recommendations due from the committee. And then under the budget in Act 78, a review of the home detention program. And I'll go into each one of these a bit more as the presentation goes on. And then the reports and updates due to the committee is an update on the replacement for the women's facility, women's prison in the state from a DOC and stakeholder group. Act 23 has various reports due to the committee, one on the community violence prevention program, one for the plan for secure placements, and the Sentencing Commission report on potentially expanding the Big 12 offenses. In Act 40, there'll be criminal justice related investments and expenditures, a report that's due from a new advisory committee. And then yours truly will be submitting a report on qualified immunity, and more on that in a little bit. So going into the committee work itself, in Act 22, on or before November 1st, this is the continuity of treatment upon reentry for incarcerated individuals. So by November, the committee is supposed to provide recommendations to House Human Services and Senate Health and Welfare regarding any legislative action needed to ensure continuity of treatment for individuals reentering the community, discharged from a correctional setting, including prior authorization for medication for opioid use disorder. I don't know if there are any, Senator Sears, if you want to kind of shed some light more on this, I can go a little bit more in depth, or if there are any other questions that the committee may have about this work.
Well, that I think stems from the issue of making sure that if somebody's on Suboxone or.
Yes, this language actually came from House Human Services Committee, my committee. So yes, when we were taking testimony on 222, we continued to hear about issues with the, I guess, shall I say, the discharge planning and essentially what it says here, the continuity of treatment between, leaving a facility and re-entering community space. And that's why this language ended up in that bill. So we continue to hear about issues with that. And we talked briefly about this last year, but didn't really, it wasn't in any legislative requirements. So now it is.
Yeah, I would just add, thank you, Representative Wood. I would just add that the importance of this is that we know statistically that people who are just released from prison are more likely to overdose than others, statistically. And part of that is if they don't have the continuity of treatment, they would, there have been problems. So.
Okay, well, I'll move on to the next slide, which is in Act 28. This is the review of competency examinations. So this is a pretty comprehensive review, actually. So the primary charge is to review whether Vermont law should permit competency examinations of defendants, in addition to psychiatrists and doctoral level psychologists trained in forensic psychology, to be conducted by any other doctoral level mental health provider, psychiatric nurse practitioner, or other professionals. And this includes a review of other states' laws and whether changes to our laws are necessary to permit such a referral. And the review is only limited to 4 meetings. That's in the legislation. And there's also an invitation for 2 members from the Senate Committee on Health and Welfare and 2 members from the House Committee on Healthcare to attend and participate in this review, and also to help develop the recommendations that the Justice Oversight Committee puts together. And this all needs to be done by November 15th. About any recommended changes it deems advisable to 134814, which is the governing statute for permitting competency examinations. And that report would go to the Senate and House Committees on Judiciary, the Senate Committee on Health and Welfare, the House Committee on Healthcare, and the House Committee on Human Services. Are there any questions on the competency examination?
I would appreciate input from both Health and Welfare Committees, Senate and House. Well, I know it's the House Committee on Healthcare and the Senate Committee on Health and Welfare, but it would be helpful to have some input on this. And you're going to research other states, Ben, or is?
Yeah, once we kind of set the schedule for when we're going to do this review, I'll make sure to have a review of the Vermont governing law and some other states. If there are any that were in mind, I could start with those, or just kind of start anew.
I think we should probably look at the other states, but I also think part of the problem is the backlog in competency examinations in this state due to there's very few psychiatrists available. And then we did hear testimony in judiciary that many offenders don't attend to meet the competency evaluation meetings, and that's left that psychiatrist, or in this case, psychologist. And I believe that the language that we passed this year and requires there's a sunset on the ability of doctoral level psychologists and forensic site be conducted by other doctoral level mental health providers. I believe we sunsetted that this year. So we want to continue to allow doctoral level psychologists to continue to do competency evaluations.
That's correct, Senator Sears. That's under subsection D of 4814, that authorization or permission for other doctoral level psychologists is repealed on July 1st of next year. So
we probably should start that at the next meeting, or the one in September.
I'll make note of that. Any other questions or comments on the competency examinations? Okay, well, seeing none, I'll move on to the home detention program review. This was put into the budget after initially the background was that the administration proposed repealing the home detention program altogether. And after debate in House Corrections and Institutions, rather than an outright repeal, a review of the program was deemed appropriate. And if I recall, there were, part of the discussion was how few people were subject to the home detention program. I believe it was under 10 at the time. I don't know the current number now. And there was testimony about really the manpower that it takes to kind of oversee people on the home detention program. So one of the revisions to the governing statute under 13 VSA 7554B was to allow passive monitoring. So it wasn't necessarily real time. In addition to that, this review was implemented to basically explore its use historically, eligibility criteria for home detention program, and any potential changes. And this is supposed to be done by November 15th, that any findings that result from the review would come in the form of proposed legislation to the General Assembly. Another part of the discussion was, if these people weren't subject to the home detention program, they probably would just end up incarcerated. So that prompted a lot of the discussion and the review of the program itself. Representative Emmons, I know that you were, well involved in this. If there's anything else that you'd like to add.
I think you summed it up really well, Ben. And one thing too that came through, we had Judge Zone testifying, and he really recommended not doing away with the program, and really was thinking if he could work with the judges to bring it to their attention that this was really a tool that they could use, because what he was finding was that nothing was coming through the courts for this. Prosecutors weren't asking for it, the defense wasn't asking for it, and even Department of Corrections wasn't. And so he was thinking if the judges could at least have this on their radar and ask at the court proceedings, it might help get more folks into it. So that was the judge's testimony, and that's one thing that we hope does come to fruition.
What was this for? Both for currently incarcerated offenders as well as detainees?
Ben, I think it can be used for both, right?
Yeah, I mean, it's really sort of that, part of that calculus of the least restrictive means to have somebody under the supervision of DOC when possible. There is an eligibility criteria. If you give me a second, I can just pull up the statute quickly. But that's a good question to ask, because one of the discussion points was, should the eligibility be expanded so that more people could be kept out of prison that might otherwise be, I guess, a good fit under the new policy. So right
So
now.
Ben, I'm not sure, is it just for folks who do not have bail or who have bail? Because I know it's gone back and forth.
So it's sort of a combination, because bail is really there to prevent risk of flight. It's not there for public protection. This is a little bit of both, because it says that when the court finds that placing the defendant on home detention will reasonably assure his or her appearance in court, so that's the risk of flight factor, and the proposed residence is appropriate, so there's that. And then in making the determination, the court considers the nature of the offense, the defendant's prior convictions, history of violence, medical health needs, past history of supervision, any risk or undue burden to other persons at the proposed residence. So there is a little bit of a different calculus. So it could, I suppose that people can go right that are already incarcerated can be subject to the home detention program. And then also those that are initially at arraignment that are not incarcerated already.
I know the former sheriff of Windham County ran a program and it was pretty successful. And I know we had several people from Bennington County involved in that home detention program. And, one that stood out was a guy who was a truck driver. He was able to continue making money, able to support his family and pay child support, etc. And would have otherwise probably been in jail. And he kept his job. They just transferred him from Bennington to Manchester.
Yeah, and another point of information for this is that this would have to be something that comes from the offender or their attorney. Under the statute, prosecutors don't ask for home detention. So it wouldn't, and I think that goes to Judge Zone's point, Representative Emmons, about the court being more educated on this option for individuals that could qualify.
Well, good. I think our agenda is getting full.
Yeah. Well, I think this would also play into our discussion maybe a little bit later when we start talking about the work crews. Because if DOC is doing away with the work crews, maybe some of these folks could qualify for home detention. Just a thought, just a thought.
Yeah. Anybody else with a comment on this one? Great.
Well, that should theoretically wraps up the work that the committee itself has to do, at least legislatively mandated work. The rest of the presentation is about work that's due to the committee, so reports and other updates, and that might prompt some other work that the committee sees fit to undertake given what's contained in those reports. So I'll start with the group update from the stakeholder group discussing a potential replacement to Chittenden Regional Correctional Facility, which is the women's prison. So during the legislative session, there was some discussion on House Corrections and Institution. There was stakeholder testimony, and I'd say that there's probably the lead group on this was the Vermont Network. And there's a sort of a coalition of other interested parties that they've been working with. And so HCI sent a letter to DOC requesting its collaboration with that stakeholder group to replace the women's prison with a trauma-informed and gender responsive facilities and programming to promote the successful rehabilitation and reentry of justice-involved women. So at least by the contents of the letter, it may not be a one-to-one facility replacement. It could be other facilities that come online to replace it. Now, formally under the letter, the update was asked to happen by January 15th of next year, and then annually, as long as the process takes, to the House Committees on Corrections and Institutions, Judiciary, and the Senate Committees on Judiciary and Institutions. But there's been apparently some progress made, so an update on that progress was requested for August of this year before this committee. Any other questions or any questions about the stakeholder group and what they're doing?
Ben, I don't have any questions about the stakeholder group, but I think it would be important for this committee to know that there's quite a bit of language in the capital bill that pertains to the replacement of the women's facility. And I know at some point we may be taking testimony on this. So Ben, I would recommend, if you look at the capital bill, which is H 493, sections 26, 28, and 29. We've put in talking about the site location, any proposals for that. The commissioner of BGS would need to report to the two institutions committees monthly beginning in September in terms of reports on site location proposals. And then that would go from September to December. We're very clear in terms of the design intent for the facility, that it would use evidence-based principles for wellness environments for supporting trauma-informed practices. And by November 15th of this year, the Department of Corrections would submit a written report to the Corrections and Institutions Committees and the Judiciary Committees regarding the proposed size and scale of the replacement facility, and it lays out what the report needs to address, which would be the bed types for specialized population in each facility, and the data and rationale used to inform the size. So those are important things, I think, for us as Justice Oversight to be aware of. I hope that's helpful.
It is helpful. My biggest concern is the size. I don't think there's any doubt that the Chittenden Regional Correctional Facility needs to be replaced. But the size of it and how many secure beds versus how many beds that would, for lack of a better term, be for pre-release.
And we were concerned about that too. And that's why the report in November is very clear that it talks about the proposed allocation of the beds in the correctional facility as well as the reentry facility, and what the data was that led up to those proposed budgets. Right. I mean, proposed proposals. And also the process is going to be right now, no one can go forward right now and make a decision in terms of the size of the facility or the structure of it until they can find some land. And all of that will be coming back in terms of how we move forward with the size of the facility and the design and structure of it. That will all happen this next session beginning in January, because the money has to be appropriated to allow them to go further into design documents. So the first thing we're going to hear in January are preliminary concepts in terms of, if we do it this way, this is what it's going to look like. If we do it this way, this is what it's going to look like. Or there could be another option C, this is what it's going to look like. And then we have to decide how we're going to move forward with it as a legislative body.
Since I can't see everybody, if there's any other comments, please feel free.
This is Senator Rum Hinsdale. I just wanted to to ask if there's a recent formative document that I might read to get up to speed. I know what it feels like when you're on the committees of jurisdiction and you live in this stuff, and someone who isn't has questions, concerns. So I wonder if there's something that Ben or members of the committee feel like would really help me know where the committee's thinking is currently.
Senator Rom Hinsdale, I can forward on the letter that came from the committee, which kind of, I mean, it's a one-page letter, but it kind of gives an overview, I think, of the committee's thoughts, and there was a lot of discussion over it. But to Representative Emmons' point, I think the capital bill, if you look at specifically section 29, talks about the report and what needs to go into it. So that would be, it's starting on what
Perhaps
page?
I did see the letter, Ben, I think from you, and perhaps sending the letter to the members of the committee and the pertinent sections of the capital bill would be helpful to at least get us up to speed at the August meeting.
Okay, I'll go ahead and do that. Senator Rom Hinsdale, if you have any other questions, feel free to reach out. And Representative Emmons, if you want to weigh in too. Sarah Robinson with the Vermont Network might also be another good resource about getting some context. My impression was that she was the lead of that stakeholder group. So she might be able to provide some more context for you as well.
I will also just say, because I have my own bias, I would be in that facility for a day a week, usually when I was the legal director for Steps to End Domestic Violence. So, I have my thoughts on how that building operated or didn't, but I just want to make sure I have everybody else's perspective.
Thank you, Ben. Thank you.
Sure. So moving on to the next report. So this is through Act 23, which was S4, the Community Violence Prevention Program. So this is a program governed by 18 VSA Section 13 that's administered by the Department of Health to work with communities to implement innovative, evidence-based, and evidence-informed programs addressing the causes of youth and community violence. So the Commissioner of Health, in consultation with others, need to report to the committee on twice, on September 1st and then again on December 1st, sort of on the status of the program. Again, those others would be the Chief Prevention Officer, DPS, Director of Violence Prevention, and the Executive Director of Racial Equity, and the Council for Equitable Youth Justice, which was recently reformed this year. And another piece of legislation to kind of bring it in line with the federal governing statute. And that council specifically has youth and family voices on it. So their involvement probably brings a lot of value to this report to the committee. Are there any questions about?
Well, I would just mention there's $5 million in the appropriations bills to this program, and it's available to communities. I haven't heard whether communities have submitted grants yet, but there's directions for communities to do that through the Department of Health. And I know that they're getting up and running. The Department of Health is right now with administrative support and so forth on the $5 million. And hopefully communities can come up with innovative ideas to help prevent community violence that we're seeing in so many towns and cities.
Can I just weigh in a little bit? I'm trying to get her to stop crying, but I also just want to make sure that when I read causes of youth violence, it also makes me think of causes of disparities in who's criminalized around behavior. If you look at some of the statistics out of Burlington, there are not more Black youth engaged in violence or committing crimes. They're in my opinion, under much more scrutiny and facing much more police intervention. So I just want to make sure that when we say causes of youth violence, we're also looking at disparities in how youth are treated when they get in trouble as young people.
That is part of the design of the program, quite frankly. But want to make clear that what I intended in this, when I introduced the bill and introduced the prevention program, it is the firearm, the use of firearms in our communities, which is and shootings and etc. And I know in Bennington, last year we had over 20 shootings, which is unheard of in small communities in Vermont. But it's here, and so it, using I just want to make clear my intent anyway in the bill was dealing with the shootings and the armed kidnappings and etc. that we've seen, and human trafficking, by the way, has been also prevalent in some of this.
That's helpful context.
And Senator Sears, just to go into it a little bit more, if I may, with, there's that grant program which factors in various aspects. I mean, preference is given to the communities that you mentioned, those that have seen an increase in violence associated with illegal drug sales and trafficking, gang activity, or human trafficking. And then, grants are supposed to build on and complement existing programs, be for the purpose of funding efforts that address violence and associated community harms using various approaches, including best available research evidence, experiential evidence, contextual evidence, lived experience of impacted communities, trauma responsive programming, and other qualitative and quantitative factors that can help the commissioner make the decisions for the grant awards. And then all of that will be part of the report that is made before this committee, and actually will continue on starting in January of next year to various committees of jurisdiction. But it would include a complete description of the grant application process and award process, or application and award process, the guidelines developed to award the grants, how many applications and grants were submitted and awarded, and then detailed descriptions of the programs and the purposes for which the grants were awarded, the impacts and outcomes of funded projects, and the descriptions of any grants applied for. So that's all the information that would come to this committee and then the various standing committees once from the Commissioner of Health.
Thanks, Ben. Are there any other comments or questions on this section? Moving along.
Moving on, the plan for secure placements, which was codified in Act 23, which was another, again, S4. And then this is coming from DCF, shall file a status report to the committee and others describing the progress made towards implementing the Raise the Age initiative that takes effect on July 1st of next year. And this is one of two reports, the other one being in December. And that applies the provisions of 33 VSA 5103C and 5206 to individuals under 20 years of age once it goes into effect. So, and for those that aren't as familiar, Raise the Age has been put off for a couple of years, its full implementation. And I suppose that this is the last hurrah, if you will, on the status of making that move for secure placements, at least.
The 18-year-old Raise the Age is already effective, so that they are already under Raise the Age, but it's the 19-year-old group that is, or under 20 group that is not. And we gave them another year, the administration. But I'm concerned, that we continue to, I don't think any of us ever expected it to take so long to establish secure facility for juveniles. I know those of us meeting back with Mike Smith and Ken Schatz, and I think Representative Emmons was in that meeting about 3 or 4 years ago. This has been kind of an embarrassment, quite frankly, to not have a secure placement. And I think it just we need to move forward. That it's having a huge impact on other programs for troubled youth, and it's having a huge impact on communities as well.
So if I can also weigh in on this, again, on the capital bill, there's $1 million that we've put in there for DCF and the Agency of Human Services, and also the Department of Buildings and General Services, but basically DCF, to really look out there for options and possibly start some design documents, knowing if there's any land available, and looking at the testimony the Corrections and Institutions Committee heard from DCF and the Agency of Human Services, is they're really looking at a campus style approach where they would have a few facilities or a few buildings for different needs, and hopefully have like some step down beds available. And that's the concept that they're looking at. And that's what that $1 million will initially go towards, doing some planning and design documents for that, if they can find the land. That's the other piece.
Well, but I would urge us to put as much pressure as possible.
Mhm.
I agree that there needs to be a plan for a long-term solution, but in the short term, we need the placements. We needed the facility 2 years ago,
Mhm.
and we still don't have one. And that needs to be some kind of a short-term solution, either with a private provider or with state employees. I don't know what the plan is, but that's really what I'm looking for. I agree with you, Representative Emmons, on the long term, having a campus style facility or whatever, but I don't think we can wait 2 or 3 years to have a facility, or 5 years, whatever it takes. They need something interim.
So maybe one thing we could do at the next meeting is have an update from BGS as well as TCF about those proposed pods. We talked about this way back last fall in November and December about building up some temporary pods. At the time, they were thinking of the correctional facility land up in St. Albans. And it might be worth to get an update on where they are
Why don't
with this.
I think we should plan it for the September, because they're supposed to give us a update at September 1, 2023. So maybe the September meeting might be, because we have the women's facility scheduled in August, and also healthcare. So I think it might be better to do September, if that's okay, because that's when the report's due.
Senator
Yep.
Sears, or maybe it's better to ask Representative Emmons. Was the only reason the Windsor facility was turned down is because the people, they didn't want it there? Because that was on state property.
Right, and they looked at the Windsor facility. BGS and DCF did look at that initially. At the same time, they were looking at the St. Albans facility. At the Windsor facility, where the building they were looking at needed a lot more renovations than they had initially thought. And also the community, they felt the community in St. Albans would be more open to it than the community at Windsor. And Windsor, there's also some activity happening in terms of really figuring out how we move forward with that property and that land in terms of contracting out with a third party to really look at options. So we didn't want to interrupt that process either for Windsor.
Okay, thank you.
And I don't know if Senator Norris has any knowledge of where the process is for St. Albans. I know St. Albans was in negotiations with the state. And I don't know where those negotiations are at this point. And I don't know if Senator Norris has any insight in that or not.
What I can tell you, Alice, is myself and Senator Brock attended that hearing in St. Albans, and there was probably 40 people there, along with the administrative staff from the OC and the commissioner, building services. I'm sorry, and I got to tell you, quite honestly, it wasn't received quite well in the greater St. Albans area. So I don't know where they are at this point in time as to what they're going to do. It was a good meeting, but it wasn't well received by the participants there. Unfortunately.
Yeah. I'm glad you mentioned Greater because it's really almost in Swanton.
Yeah.
The facility. I think the mailing address is actually Swanton.
Yes, I believe that you're correct, but it is in St. Albans town. It appears as though the biggest point of issue was honesty from Department of Corrections as to the improvements that have been made on the facility over many times. And obviously it started as a diagnostic unit. Since then it has become something quite larger than that. And now they're talking about putting in those pods, but they were temporary pods, I might add. They weren't permanent pods, but unfortunately, it still wasn't received quite well by the taxpayers there, the residents of St. Albans town.
Well, there's a long history there. In the 1960s, they promised a youthful offender facility for those under 25. I think it was going to be 40 beds total. And the rest is history.
Yeah, and I worked there in I started there in the fall of 75, so it's grown even since then.
Yeah, I started there in 1969. When I graduated from UVM as my first job after graduating. Correctional counselor. I didn't stay long enough to have it open. I got moved around and there was another opening and I took that at a different facility. So I never actually, I got all my training at St. Albans and it was all.
Who is the commissioner of BGS? I forget her name.
Her name is Jennifer Fitch.
Jennifer Fitch. She was there, so obviously she'd be the one to reach out to us to get any further information as to where they are.
All right. Anything else on the plan for secure placements and raise the age initiative, which we can't forget that. I mean, that's been put off twice and go ahead, Ben.
Sure. So the final report from Act 23, not the final report for the committee, is from the Sentencing Commission about the expansion of the Big 12 offenses. And it's quite an extensive list of things to consider. You'll see here, this is just some of the offenses that are being considered. It's not comprehensive, but this should be submitted to the committee before December 15th or by December 15th. About which Big 12 offenses can be transferred from the family to the criminal division under 33 VSA 5204A. So some of the offenses being considered: first or second degree arson, stalking or aggravated stalking, domestic assault, really the different permutations of that, selling and dispensing a regulated drug with death resulting using a firearm while engaging in the selling or dispensing of a drug, carrying a dangerous or deadly weapon while committing a felony, lewd and lascivious conduct, both with and without a child, eluding a police officer with serious bodily injury or death resulting, grand larceny, hate motivated crimes, drug or human trafficking, violation of abuse prevention orders. So the list goes on. It's quite an extensive review. If there are any questions about that. Seeing none, I will continue on to.
Can I just comment real quickly on that, Senator Sears?
Sure.
Yeah, I also understand that one of the offenses that's going to be looked at is burglary into an occupied dwelling, and whether that should be taken out of the offense that should go to a criminal, to the criminal court. Just wanted to make that comment.
Yeah, that's been you're correct. You probably should include that in the list. An occupied dwelling, the definition doesn't necessarily mean somebody's there. Could be a camp. And somebody breaks in to steal whiskey or something in a deer camp, and that could be considered a big 12 offense.
Yeah, and Representative Lalonde, to your point, yeah, part of that consideration about whether that should remain is there's also the ability to, or the legislative mandate to review whether an alternate or redefined version of the offense should be included. So it's really any way you slice it for that one. Seeing nothing else on the Sentencing Commission report, Act 40, which was S14, this creates a report on criminal justice related investments and expenditures. That is one report that will, so there are kind of two reports that have related purposes in this act. One is every 3 years, the Vermont Statistical Analysis Center, which is also really operated by the Crime Research Group, is doing a very comprehensive report on recidivism rates, desistance rates, and a whole bunch of factors that are related to those factors, really to try and assess if the investments that the state has been making over the past 10 to 15 years, really related to justice reinvestment and beyond, are starting to take hold, if there are some trends associated positively or negatively with those investments. So that's one part of it, but that's a couple years away. Before that, starting in November of this year, there was a council established to create a unified and collaborative approach to support state and local community-based programs and services that are consistent with the state's restorative justice policy. So that committee shall, and it's made up of all the interested stakeholders, DCF, DOC, the Vermont Network, the boots on the ground folks that are working in CJCs. And it's for them to really come up with considerations and recommendations to establish a more sustainable planning and funding structure to administer these programs, and whether or not modern data collection systems need to be created. And then in addition to that, submit recommendations to the Commissioner of Corrections for the appropriate allocation of not more than $900,000 from the JR2 line item of the DOC budget for the upcoming year to support these programs. They also make this recommendation to the Commissioner himself, and that recommendation comes before September 1st, so that it can then be rolled into the proposed budget that the governor submits to the legislature. So there are a lot of moving parts to this one, but I think a good way to think about it is sort of the next step, the continuation of justice reinvestment, and really, and like it says, creating that more sustainable funding and organizational model. And all the players that are really involved in it now are at the table under this advisory council to try and create that plan if necessary. And it will come to the committee by November 15th of this year and annually thereafter.
This one.
If there are any questions about this or not seeing any, I can move on to what I believe is the final report due to the committee this summer, or this interim session, which is the qualified immunity report. So the budget this year extended the due date of the report to November 15th of this year. It will also be submitted to the various standing committees on judiciary, and it goes into 9 discussion points, really outlining the history and current state of qualified immunity in Vermont and in the Second Circuit, how it applies to law enforcement officers, whether it essentially stands in the way of any civil remedies for allegedly aggrieved victims of law enforcement action or conduct. It's very comprehensive, so I will be working to finish that report this summer into the fall. It's already quite extensive.
I'm sure it is, Ben. A lot more than you expected, I'm sure.
Yeah, that's okay though. And then finally, just a summary of the schedule about the work day, the due dates for the reports submitted to the committee and the deadlines for its own work. I recommend this is probably just a good sort of document to keep just for reference about what's going on for the summer. And if you have any other questions about it, feel free to reach out to me directly. Yeah, if there are any other questions, I'm happy to answer them. If not, thank you, Senator Sears, for giving me the stage.
Thank you, Ben. And the only suggestion would be that we have copies of this document at the next meeting when we're live, so that we can go over it. And I appreciate all the work that went into it. And so as long as we have copies at the next meeting, I think it would be helpful.
Yeah, I'll work with Peggy to get those to the committee members.
Yeah, maybe we could actually mail them. It's an odd type of thing to do. We usually email stuff, but maybe mailing hard copies would be helpful for everybody, so we have a good idea of what we're up against.
Okay. Yeah, when I can get back into the State House, I'll get that together.
Yeah, we understand. It may be a few days. I'm one positive of the Zoom and the JRH6 is that we're able to make decisions today and vote on things if we need to. But I would say, and knowing that I probably have to travel the furthest, it would have been a difficult trip, finding which towns you can get through and which you can't. So it's very fortunate that we're able to meet in this manner. Thank you, Ben, very much. Very helpful. And we're almost on time for an update on the Department of Corrections and particularly training, recruiting, fatalities, and work crew from Nicholas Demmel, the Commissioner of Corrections, and welcome, Commissioner. Hopefully everything is good in your area in terms of the flooding, and you're able to join us. We appreciate that. I see Isaac Dino from your office is also with us, and I know I mispronounce his last name frequently.
Morning, Senator. Thank you very much for the opportunity to be here. Apologize, you're catching us at a bit of a disadvantage today as we try to manage our way through what is turning out to be a pretty robust crisis across the state. I don't know. I'm in my office in Waterbury. I don't know if you can see, but what was once a parking lot and then some fields across the street is now a raging river nearly within a couple of feet of the building at this point. So we're going to have some significant damage across the state. And I guess it's appropriate to start the meeting by just flagging that we've had several staff across the state impacted by this disaster, evacuated from homes, significant home damage, stranded because roadways are impassable, And yet, each of our 6 correctional facilities is up and running today, fully staffed, with no impact to our operations. And I think that's a testament to the service that our staff and that the state emergency response staff put out every day to make sure that this state and its operations can continue. And so I want to thank our staff and the emergency teams that are out today trying to help facilitate access and make sure that people are safe and healthy. But particularly call out the correction staff, who I think often do get forgotten in the mix, but are on the front lines every day, ensuring that our system is up and running and running safely.
Well, thank you for that, Commissioner. Thank you. And
Certainly.
on behalf of the committee, I express our appreciation to your staff as well.
Thank you. And I know this committee in particular understands the pressures and the impact and the service that our staff put in. And I don't need to tell you because you've seen it and frequently get to hear from our staff. But I think it's important to flag in any public forum that we have to just really appreciate and express our gratitude to that team. If you will permit me, I'll try to keep my remarks fairly short today. Because we do have a few other things going on and I don't want to take time away from that too much, but I did want to make sure that we got you some updates that you had requested. So we have a short deck we'll burn through quickly, and then I'll answer any questions that you have, and we can go from there. So there are a couple of key points that you asked us to brief on today, and that's our staff and staffing situation. You asked us to talk about fatalities in our system and the work crew program. We also wanted to provide you a couple of updates on the transition of our healthcare system, which has just occurred on July 1st, as well as some changes to the home detention program that we made and that will take effect in about a month or so. So we can push on and talk about staffing. The staffing crisis remains the top priority of the department, and finding ways to resolve the staff vacancy rate, particularly among our security staff positions, is our #1 priority. Fortunately, we've made some progress in the last year. So when we briefed the committee last year at this time, our vacancy rate among security staff was over 30%. I'm proud to say that today it's just over 20% at 20.8, and that's because of a substantial body of work that's gone in by the part of the department, but also our labor partners in reaching side letter agreements that really provide targeted enhancements to our staff and the reimagining of our system, and that work continues. The department, as you know, released a stability and sustainability plan in late summer of last year. We believe that that's been hugely impactful on our ability to recruit and, more importantly, to retain key staff. We changed schedules in our system with an optimized schedule to try to provide a 50-50 work-life balance, meaning staff could work 50% of the days in the year and have 50% of the days off. That is operating at 4 of our 6 facilities, and we hope to get the remaining 2 facilities into that schedule as soon as possible. Importantly, those facilities, Northern and Northwest, so Newport and St. Albans, are some of the greatest recruiting facilities that we have statewide right now, which is very promising. It's also been heartening to see that since September of last year, when we implemented these new schedules and really focused our attention on recruitment and retention efforts, that we have been running the largest academies in our department's history. Every academy since that time has been running hotter than the average number. And we're excited that our next academy, which starts July 31st, already has 44 confirmed cadets with 16 still pending background investigations, meaning the total number of attendees could be well over 50. To give you some context, a normal academy in the Department of Corrections is 20 cadets. So that would be more than twice the size of a normal academy. We're also finalizing a plan to resolve the need for field staff to provide hospital coverage across our system. So as many of you know, historically, the facilities maintain coverage of an individual when they have to go to a hospital. But since the COVID-19 pandemic, that work has been managed by our field staff, requiring them to be on standby. So they have limitations on what they can do in their off hours. And then if somebody does in fact go to the hospital, they are activated and have to go do that coverage. That's been a huge pain point for our field staff, and we know how much that's impacted them. So we've worked over the last several months to really create a plan to resolve that as quickly as possible. That was done, though, with the reality that the number of people going to the hospitals from our prison system has increased substantially since the pandemic. And so the structure that we had in place to manage that system prior to the pandemic no longer would work in the current environment. And we don't anticipate that hospital visits will decrease. I think it would be fair to assess that the medical needs and the complexity of those needs for our population will continue to increase over the coming years as our population grows older and sicker. And so we needed to design a new way to manage that process. And so we look forward to releasing that soon. We also have a meeting with our field staff later this week and with VSEA, our labor partners, to discuss their views on that and for us to discuss some of the plans we have in place to resolve those issues. And then finally, I highlighted it a bit before, but we do have a new side letter agreement that was enacted earlier this year that will extend through the end of FY24. And so it's a much longer agreement than we've had in the past for the side letters. And it set out a variety of targeted enhancements that we think have been supporting our facility staff. And we're hearing very positive things about that work and the schedule changes, which is feeding our ability to retain staff. And certainly, as you see from the academy numbers, recruit staff. From there, we'll provide you just a quick update on our healthcare transition. So as you know, the department contracts out with a medical contractor to provide comprehensive health services in all 6 of Vermont's state prisons. That healthcare provider changed hands on July 1st, and we are still in the transition, but the transition has gone very well to date. The new contract will extend through 2026. And it provides the full suite of medical services up to a hospital level of care. So that would include medical, mental health, dental coverage, pharmacy, emergency services, et cetera, up to a hospital level of care. And the goal in transitioning the contract now was really to recognize and understand that the health needs of our population have changed dramatically in the last few years. Those changes were occurring before COVID, but COVID certainly supercharged the changes, and I think permanently changed the future trajectory of the health of individuals who were serving in our system. And so our contract needed to be adjusted to meet those new needs, particularly as we look to mental health and substance use needs. And we are continuing to strive for the Vermont Community Standard of Care, meaning the same level of care that's provided in any of Vermont's excellent hospitals across the state will be provided in Vermont's correctional system. We continue to work on that, and we're excited to have a new partner in place to help us with that process. That also leads to conversation about fatalities that have occurred in the state system. We've had a number of fatalities in the last 2 years in our correctional system. The vast majority of those fatalities were natural causes deaths, largely among older individuals. But we have also had self-harm incidents resulting in death and overdoses resulting in death. This has led to a wide variety of work across the Department of Corrections, but also in partnership with the Defender General's Office and other agencies across the state to really study and understand why deaths are occurring and if there are any trends that we can identify in order to prevent deaths in the future. That process is ongoing, and I'd like to pause and just deeply thank the Defender General and his office for the work that they've taken on with us and the partnership they've shown. And I think it's my opinion that the Department of Corrections deeply cares about this problem and wants to ensure that we can prevent death wherever that's possible. But I've really appreciated the Defender General stepping up and meeting us there and recognizing that we're both after the same goal, even though we approach the problem from different perspectives. And that's been really healthy and helpful in our efforts to try to understand any problems that we have in our system and take some action to resolve those. One of the other areas that we identified as a challenge was the department is actually very good, and it's laid out in statute that we have a series of automatic investigations that are initiated when an incident occurs, and particularly when a death occurs. Those reviews occur. We have both internal reviews, independent external reviews. The Defender General, the Vermont State Police conduct reviews. But one area that we identified that we were not very strong at is explaining at the end of those processes what our findings were and documenting that for the public. One, to instill trust that those processes are working because they are, but we haven't talked about them. And two, to ensure that we really are true to our commitment that we are going to be as transparent as possible so that the state understands what's happening in its Department of Corrections. For those reasons, we sought some outside help from partners at Downs Racklin Martin to review our processes and develop a system where we can make public our findings of those investigations after they're concluded. And we think that this will, like I said, increase faith and confidence in the Department of Corrections interest in trying to do the best that it can in these instances, but also increase our transparency with the public to ensure that they are aware and informed of what's going on. We hope that process will conclude later this summer, and we'll have that process in place and begin to document those things for the public.
Could we
Sorry.
go back? I just want to make sure I understand. It's one thing when I realize with an older age population that people will have significant health issues.
Mhm.
And that often results in deaths. But I'm also concerned about the mental health and substance abuse that you spoke of earlier in
Mhm.
terms of what's available. You have a much higher population of people with significant substance abuse or mental health problems
Yes.
than would be in the community. And it might be helpful at a future meeting, say in August, to better understand what is available for mental health for offenders who are incarcerated and for those that are having significant substance abuse issues and how we're dealing with that. Because I think to be, I don't know how, given the staffing issues and given the difficulty in finding mental health professionals around the state and substance abuse folks around the state, counselors, etc. Even and within the facilities, how you're providing that mental health care and substance abuse care.
Yeah, we'd be happy to provide an in-depth briefing on the mental health system. I think as I look at our,
Do you have a percentage of offenders with serious mental health problems?
we do, I mean, it's a difficult number to pin down in so much as we know how many folks are on mental health related medications. We know how many folks have diagnosed mental health issues, but we know that there's a spectrum of mental health challenges. And so it's difficult to pin that down exactly with one number. What we do know is the mental health challenges our population is facing are increasing, and we are observing that folks are coming in to our system quite sick, both physically ill and also facing robust mental health challenges. And so there are a couple of data points we can look at to try to measure that, but it is challenging to say this is the number of people with a mental health challenge because of the wide spectrum that exists there. On the
But
substance use
particularly
side,
going to fatalities. I'm sorry, I interrupted. You were going to speak about the substance abuse.
I was just going to say, and I think you've heard this before this year, but on the substance use side, you know, on average, about 60% of our population has an opioid use disorder, just opioids. If we were to expand that statistic to capture any type of substance use disorder, alcohol, other types of drugs, I think it would be safe to say that number is close to or exceeding 90% of our population. So we know that substance use is a major challenge that faces the population that we're serving as well.
I was particularly, what I was going to ask next, if you could also review it, perhaps at the August meeting, the protocols when someone is suicidal or makes an attempt at suicide.
Yeah, we
That-
would be happy to do that.
Please go ahead. I interrupted you.
No, that's okay. Sorry that I haven't paused for questions.
And can I just
Sure.
question? Thanks, Senator Sears. I appreciate your line of questioning. I'm curious with older age folks, just if you track like the cost of end of life care, it's so much more expensive outside of the prison system. And I wonder too, if there's even more additional costs for end of life care if you are doing hospital level care. And I guess that leads me to wonder, like, the costs and benefits of keeping people incarcerated in an older age if we're spending a lot of money on people who might otherwise be deemed no longer a threat. And then they're compounding their health issues inside the prison system.
Yeah, those are excellent questions, Senator. So there is not necessarily an increased cost for the Department of Corrections for an individual who is receiving older care or end of life care because of the way our contract is structured with the medical contractor. However, I think that there is a policy question there about whether individuals who are in end of life care requiring a hospice type care or really reaching those end of life, and whether it's appropriate for that care to be provided within a prison system. I'll tell you, in the House Corrections Committee this year, we spoke at length about different ideas about how to get those folks out of our system. And there were ideas advanced on, you know, kind of an end of life release type of setup. What I'll tell you though is the structure largely exists to get those folks out of the system. We use a medical furlough process. The department, from its perspective, is willing to be very liberal in the use of that for folks who require nursing home level of care, hospice, end of life care. But what we found is in nearly every instance where we want the individual to move to a more appropriate setting, that setting doesn't exist. There's no bed available for them. And so from the department's perspective, our option is we keep them in our system and provide them a robust level of care, really the best that we can, or we take them to an emergency department and drop them off. I mean, there are very few options for us. And so unfortunately, this year in particular, we've had multiple individuals die in our system who are receiving hospice care, and our staff and our medical contractor really went out of their way to make that situation the best that they could for those individuals. But I think many would argue that it would have been more appropriate for them to die in a different setting.
Senator Norris has a question.
Yes, thank you, Senator Sears. Good morning, Commissioner Demmel.
Morning,
Senator
Sen.
Bob Norris, Franklin County.
Nice to see you, sir.
I'm sure that the other members of the committee have received the same thing that I have from a special interest group from down south. My question to you is, and concern is, I guess I would like to see at the next meeting or something, they sent a bunch of stories, and they're very compelling stories, I might add, but as we well know, there's always two sides to a story. What I'm wondering is, Department of Corrections protocol and/or standard operating procedures offer a yearly physical to anybody requesting it. And more importantly, I'm reading where they submit a letter or a request to see a doctor, what the turnaround is on that and what the procedure is for that, for those people in your care and custody.
Yeah, so individuals are permitted regular access to medical care, to include regular physicals. But we could probably pull some statistics on turnaround time for sick slip submissions. Sick slips are what we call them when an individual wants to see a medical provider for some reason that's unscheduled. They would submit a request. We call it a sick slip. My understanding is those are turned around relatively quickly. And also we have medical staff that go into the units every day, either during a medical pass time where they come around with medications for folks or to check on individuals. And so they're regularly in the units. But I think that's certainly something we could pull down information for you and present that at the August meeting or a future meeting if that'd be valuable to you.
I would appreciate that, yes.
I believe we're going to have that group join us in August. And you might, I don't know if Peggy's posted the that email that Senator Norris spoke of on our website, but certainly we would share with you the email and their documents.
Yeah, I appreciate that, Senator. The only other thing I would add there is we also were notified of that, I think over the weekend, that they intended to send you some information. And I think that the challenge for me is we've, at least since I've been here for almost 2 years now, have really sought out engagement with any group willing to talk to us, with family members, stakeholders, advocacy groups, with our labor partners on other topics. We really value that engagement and take on the information that we're provided and are continually seeking to improve our system. In this case, we haven't had the opportunity to engage with this group yet, and we're sending them a letter asking for that level of engagement because they do have a story to tell, and it's an important one for us to listen to. And I think as evidenced by my work with the Defender General, I think our approach has been, we're going to get better results if we can work on it together and bring people to the table. And we've tried to do that in many different facets of our work. And so we would certainly welcome that opportunity with this group as well.
Senator Werner?
Thank you, Senator Sears.
Benner, I'm sorry, but
Commissioner, I am curious, we all get older, of course, that's inevitable, but the getting sicker part concerns me. And I'm wondering if you could speak either now or at a future date as to the nutritional profile of the meals served and the fitness available so that the people who are incarcerated have the best chance of not getting sicker when they are incarcerated. Thanks.
Yes, absolutely. We'd be happy to brief on that.
great. The name of the group is Vermont. No, God, I just lost. Vermont Justice.
Thank you, Senator.
Yeah, and Peggy will email you a copy of the email. All right, if you want to continue on.
Sure. So next, I'd like to provide an update on something that we spent a good deal of time talking about in the legislature this year, and that's the home detention program. The home detention program in Vermont is unique in that it has very specific criteria for folks who are detained but not sentenced to be in a home detention setting under the supervision of the Department of Corrections. It's pretty rare. This is one instance, but it's pretty rare that the Department of Corrections supervises individuals in the community pre-sentence. And so one of the things we noticed with this program was that it was, in our opinion, heavily underutilized. There were only 10 individuals, even today, there are only 10 individuals on the program. Hugely labor intensive for the Department of Corrections. And so in some conversations with the judiciary, with the Defender General and others, we initially intended to find a way that the department could extricate itself from the system. And instead, what we determined was there's a better way to administer the program that will bring down the impact on our system, but also increase the possibility that people could take advantage of a home detention setting versus an incarcerative setting while they await trial. And so the department revised its administration of the program, which will ultimately take effect on August 1st, because we wanted to give the courts ample opportunity to make any adjustments that they needed to for the 10 individuals already on the program. But there's really two major changes that the department's taking on. One, the electronic monitoring component of it will move to a passive electronic monitoring system. That simply means that there will not be somebody on standby overnight responding to the electronic monitoring, but that it'll be checked during normal business hours. That in practice will not significantly change the supervision of the individual, but for the department, it will significantly decrease the impact of this program on our staffing issues. And then the second part is under the law, there are 3 entities who can make a request for home detention. It's the individual, the defendant, or their lawyer, the court itself, or the Department of Corrections. And that's not an option that we have exercised much in the past. And so we've adjusted our policy to say, for anybody who meets the basic criteria laid out in the statute, the department will make an automatic referral to the court for that individual to be considered for home detention. That's always been an option of the defendant or their attorney, and for the court and for the Department of Corrections. But at least from our perspective, we've not taken advantage of that authority. And so we're going to begin doing that for anybody who meets the criteria. We hope that means that the program will be better utilized and may afford individuals who would be suitable for home detention to begin using it, and also decrease the impact on our system. And so I think ultimately that policy change will be kind of a win-win situation for everybody involved.
How many people are actually held on home detention? You said there's 10 currently, but how many people are in jail for non-listed, non-violent crimes?
Well, I don't necessarily have the non-listed, non-violent crime number in front of me. What I could tell you today is we have just over 1,300 incarcerated individuals in total. Of those, about 500 are detainees, so individuals awaiting trial.
That's higher than I expected.
Yeah, and that's been running pretty hot, I would say, over the last couple of years. Our overall population is down substantially, as you well know. And interestingly, over the last 2 years, we've really been keeping steady the sentenced population number, but the detained population number has increased and has stayed pretty high.
It's about 200 higher than what at the pandemic level. Am I correct? It was around 300 during the pandemic.
Yeah. So that's a tall order for sure.
Commissioner, this is Alice. Of the 500 detainees, how many of those are federal detainees? Is that included in the 500?
So today we have 73 federal detainees. That is included in the total number. So the state detainees would be about 420 or so.
And how many of the state detainees are women?
So we have just over 100. We have 104 women total today. I don't have the breakdown in front of me at the moment, but it's been running about 50-50 lately. So I'd say we could estimate that about 50 of the incarcerated women are detainees today. I can pull that exact data. I just don't happen to have it right in front of me.
Right. Thank you.
Thank you.
Okay, so then the final topic that we were asked to brief on today is the work crew program. As I think this group knows, the department is winding down the work crew program for the state. We are working with the state's attorneys and within our own system to design alternatives that are more needs responsive to the individuals that are being served. But the program as it existed was really not meeting the policy objectives of the legislature, the Department of Corrections, and was beginning to have an enormous financial impact on our state. This is another program that was significantly underutilized. So 5 years ago, the program was about 70% larger than it is today. When we notified that we were winding down the program, we had 64 individuals who were on a work crew sentence at that time. But at the same time, we had nearly 3 times that who were on warrants for not participating in work crew. So for every one individual who was in the program, there were 3 other people out on outstanding warrants who would be arrested for not participating. That was not meeting the policy objectives of the department or the Justice Reinvestment Initiative. And so we began to assess the program's viability and what it was providing to the state. The other issue here is a budgetary issue. So at 64 individuals, the program's cost for FY24 was estimated to be $3.9 million, which works out to about $60,000 per individual on work crew. For those who are familiar with the system, what would happen is an individual would be sentenced to up to 15 days within, I think, a 60-day period where they would have to come and participate in some type of work crew. That can be a variety of different jobs around the state that we had set up, often mowing lawns or groundskeeping, that type of work, cleaning up fish and wildlife, boat docks, things of that nature. So it was a pretty high cost per individual, and we were seeing that it was underutilized and really not meeting our policy goals, which is what resulted in us winding down the program. I think it's important to call out that in the Council of State Governments report on Vermont in the Justice Reinvestment Initiative, they identified that work crew violations were the leading cause of return to incarceration in the state for technical violations. I think even maybe more startling is if you combined curfew violations, violent threatening behavior and sex offender condition violations and domestic violence combinations all together, they still would not reach the level of returns to incarceration that work crew is having in our system. And so as we look to modernize the practices in the Department of Corrections and really work to keep individuals out of our system, particularly on technical violations for short periods of time, this was really the primary target of the policy work is to eliminate this program and find an alternative. Now, we've heard from state's attorneys and the defense bar that they enjoy using this tool, that the tool can be valuable for different reasons, and I'll let them explain why they think it is valuable, and I think that they're right to highlight those things. But I think that in conversations, particularly with the state's attorneys that have been very constructive, there are some alternatives that we can get to that could provide a middle ground option for plea bargains and for the defense and prosecuting bars, but that don't have this type of policy impact for our state. And so we'll continue to move forward with that work in partnership with the state's attorneys and the Defender General, and be happy to brief on that when we have some more details about what alternatives could look like.
Do you have any sense of geographic use of the work crew? I mean, are there parts of the state that are counties that are using it more than others, and where it seems to be working with fewer returns for incarceration?
Yes, in conversations with the state's attorneys and then looking at our own data on the topic, we have a pretty good sense of where it was well used. Rutland, Washington County, Chittenden County, pretty use the program more than other areas. I can tell you in Bennington, they don't use the program at all. And I think we could drill down for anybody on the meeting, or if there's questions after, we could provide you a sense of the utilization rate in your own areas.
Well, I was particularly wondering if certain areas of the state are doing better than others, and if we want to cut that off, for example, for Rutland County, which is using it, as you just said, effectively.
Yeah, I will just remind you, Senator, though, the total utilization in May when we decided to wind the program down was 64 people statewide. So even in the places that are using it robustly, it's still pretty few in number.
Well, all right, any other questions or discussion with the commissioner?
So let me ask the commissioner this. I raised this earlier this morning, Commissioner, on the expansion or redesigning of the home detention program. Would that incorporate some of the folks that would have gone to a work crew? Or not?
Possibly. I mean, the home detention option would exist prior to an agreement. And so the work crew is actually a sentence that is agreed to or imposed by the court. Whereas the home detention happens prior to that part of the judicial process. So basically, if I were arrested today, hopefully I won't be, but if I were, and up until the point that I'm sentenced, I could potentially be eligible for home detention if I met the criteria. Whereas work crew would not pick up until I was sentenced by the court.
Okay, thank you.
Any other questions? All right. Commissioner, we'll let you get back to the job at hand, and hopefully, where did you park?
It's a good question. I don't know if you're too familiar with the Waterbury complex, but there's a horseshoe on the other side of the building. That's still above water, so my car's over there.
All right, well, any other questions for the Commissioner of Corrections? Commissioner, thank you. We look forward to continuing the conversation on a number of these important issues.
Thank you very much.
We are a little bit early in breaking for lunch, which is, the cafeteria is closed today, by the way. So you're on your own. But I wonder, Peggy, if we could get a hold of the 1:15 folks. We were scheduled to adjourn for lunch at 12:15. If everybody could be back at 12:45.
I will reach out to them and see if they can come. John Campbell will not be here. Matt is here. I'm assuming, Matt, you'll be able to come back at 12:45. I'll reach out to Steve Howard and Judge Zonay and see if they can come.
Yeah. Is anybody from the state attorney's gonna be, is Tim gonna join us?
Yes, I believe he is.
Okay, that's good. All right, great. Thank you all very much. We'll get back.